Hey guys, Amateur Law Prof here. As you all know by now, I'm a civil litigator, and I figured it would be fun to take you on a journey of the rules that govern civil lawsuits. Now, we call those generally the rules of civil procedure. These rules govern major things we do in court. Since this audience is not all in one state, I'm going to take you through the federal rules of civil procedure. These are the ground rules for every civil action in federal district court. For fun, we're going to go in order. But before we get to the actual rules, it's important to know why we have these rules. So before 1938, federal practice was a maze. At law, you followed the Conformity Act, which meant federal courts copied whatever procedural quirks the state had. In equity, you followed a totally different set of federal equity rules. And then you had admiralty, I'm pointing over to the Puget Sound. It had its own set of rules too. 3 lanes, 3 vocabularies. If you sued for money, you used the law lane. If you wanted an injunction or specific performance, you used the equity lane. And if you were on the water, you were in the admiralty land. Well, not land, but sea. At law, the game started with forms of actions. Think assumpsit for broken promises, trespass for direct harms, trover for conversion, replevin to get your stuff back, ejectment to kick someone out of land. If you picked the wrong form, you could lose on a technicality, even if you were right on the facts. Equity ran on bills, answers, demurrers, and a judge in chambers. Same dispute, different door, different tools. Now, states tried to fix this with what we call code pleading. Some did it well, some did it painfully. Meanwhile, federal courts were stuck mirroring 50 flavors of state procedure on the law side while keeping a separate federal equity track. Chaos, delay, forum shopping followed. Now, businesses that operated across state lines absolutely hated this. The judges hated it. Clients were paying the bill. Enter the reformers. Roscoe Pound threw a grenade in 1906 about public dissatisfaction with the courts. Academics like Charles E. Clark at Yale and Edzard Sunderland at Michigan pushed for simple, uniform rules that decide cases on the merits instead of magic words. Congress finally got its act together with the Rules Enabling Act in 1934. It gave the Supreme Court the power to write procedural rules as long as it didn't change anyone's substantive rights. Chief Justice Charles Evan Hughes, he appointed an advisory committee. Now, this included former Attorney General William D. Mitchell, who chaired it. Charles E. Clark served as a reporter, which meant that he is the chief drafter. They pulled from the very best of equity management, the better state codes, and their own practical trial experience. The goal is one civil action, national uniformity, and decisions based on facts, not traps. In 1938, the rules of civil procedure take effect. Law and equity merged into one case. That's Rule 2. You file a short and plain statement of the case, and that's Rule 8. You get broad discovery rules to find the truth, Rules 26 through 37. Judges manage the case so it moves forward, and that spirit is baked into Rule 1. Just, speedy, inexpensive, all at once. Why they did it is simple. The old system wasted time, encouraged games, and punished ordinary people for lawyers' mistakes. The new system was built to be national, flexible, and focused on the merits. Later amendments fine-tuned that engine. Class actions get modernized in 1966, sanctions and case management sharpened in 1938, disclosures arrive in 1993, e-discovery in 2006, and proportionality got centered in 2015. Different decades, all the same mission: make cases fair and efficient. So that's how we got the rules, from a 3-lane mess down to one federal playbook with judges and parties responsible for getting a fair result without burning a pile of cash. Well, let's be honest here, burning a smaller pile of cash. Anyway, if you want to learn the rules along with the rest of the class, be sure to follow. Next up, we're going to do Rule 1. Until next time.